On the basis of control, holding and subsidiary companies holding and subsidiary companies are related terms. A company is a holding company in relation to one or more other companies, means a company of which such companies are subsidiary companies. Section 246. For the purposes of this clause, the expression company includes any body corporate, whereas Section 287 defines subsidiary company in relation to any other company, means a company in which the holding company controls the composition of the board of directors or exercises of controls more than one half of the total voting exercises or controls more than one half of the voting power either at its own or together with one or more of its subsidiary companies, provided exercises or controls more than one half of the total voting power either at its own or together with one or more of its subsidiary companies, provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed. For the purposes of this section, a company shall be deemed to be a subsidiary company of the holding company, even if the control referred to in subclause 1 or subclause 2 is of another subsidiary company of the holding company. The composition of a company's board of directors shall be deemed to be controlled by another company if that other company, by exercise of some power exercisable by it at its discretion can appoint or remove all or a majority of the directors. The expression company includes any body corporate layer in relation to a holding company, means its subsidiary or subsidiaries. A will be subsidiary of B if B controls the composition of the board of directors of A. That is, if B can, without the consent or approval of any other person, appoint or remove a majority of directors of A. A will be subsidiary of B if B holds more than 50% of the share capital of A. B is a subsidiary of A and C is a subsidiary of B. In such a case, C will be the subsidiary of A in the like manner. If D is a subsidiary of C, D will be subsidiary of B as well as of A. B subsidiary of A. B will be subsidiary of A, and so on. Status of private company which is subsidiary to public company in view of section 71 of the Companies Act 2013, a private company which is subsidiary of a public company shall be deemed to be public company for the purpose of this act, even where such subsidiary company continues to be a private company in its articles. Associate company, section 2 6 Section 2, subsection 6, in relation to another company means a company in which that other company has a significant influence, but which is not a subsidiary company of the company having such influence, and includes a joint venture company. Explanation: for the purposes of this clause, the expression significant influence means control of at least 20% of total voting power, or control of or participation in business decision under an agreement. The expression joint venture means a joint agreement whereby the parties that have joint control of the agreement have rights to the net assets of the agreement. On the basis of access to capital, listed company has, per the definition given in section 252 of the Companies Act 2013, it is a company which has any of its securities listed on any recognized stock exchange, provided that such class of companies which have listed or intend to list such class of securities, as may be prescribed in consultation with the Security and Exchange Board, shall not be considered as listed companies, whereas the Bud securities, as per the section 281 of the Companies Act 2013, has been assigned the same meaning as defined in clause H, section 2 of the Securities Contract Act Regulation Act 1956. Scan Steel Roads Limited is a public limited company whose shares are listed in the Stock Exchange, Kolkata. Hence, Scan Steel Roads Limited is a listed company. The reason for calling it listed is because the company and the stock exchange have signed a listing agreement for trading of shares in the capital market. Unlisted company means company other than listed company. Other than it is a company which has any of its securities listed on any recognized stock market. Other company. Government company, section 245. Government company means any company in which not less than 51 of the paid up share capital is held by the central government, or by any state government or governments, or partly by the central government and partly by one or more state governments, and the section includes a company which is a subsidiary company of such a government company. Explanation: for the purposes of this clause, the paid up share capital shall be construed as the total voting power, where share with differential voting rights have been issued. Government company, at least 51% of the paid up share capital held by the central government or any state government or governments, or partly by central government and partly by one more state governments. Foreign company, section 242. It means any company or body corporate incorporated outside India, which has a place of business in India, whether by itself or unagent physically or through electronic mode and conducts any business activity in India in any other manner. Formation of company with charitable objects, etc. Section 8 company. Section 8 company. Section 8 of the Companies Act 2013 deals with the formation of companies which are formed to promote the charitable objects of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, etc. Such company intends to apply its profit in promoting its objects and prohibiting the payment of any dividend dividend of its members. Examples of Section 8 companies are FICCI, ASSOCHAM, National Sport Club of India, CII, etc. Power of central government to issue the license. Section 8 allows the central government to register such person or association of persons as a company with limited liability without the addition of words limited or private limited to its name by issuing license on such conditions as it deems fit. The registrar shall on application register such person or association of persons as a company under this section. On registration, the company shall enjoy same privileges and obligations as of a limited company. Revocation of license. The central government may order revoke the license of the company where the company contravenes any of the requirements or the conditions of this section subject to which a license is issued or where the affairs of the company are conducted fraudulently or violative of the objects of the company or prejudicial to public interest, and on revocation the registrar shall put limited or private limited against the company's name in the register. Before such revocation, the central government must give in it a written notice of its intention to revoke the license and opportunity to be heard in the matter. Order of the central government where a license is revoked then the central government may in the public interest order that the company registered under this section should be among amalgamated with another company registered under this section having similar objects to form a single company with such constitution, properties, powers, rights, interest, authorities, and privileges, and with such liabilities, duties, and obligations as may be specified in the order, or the company be bound up penalty or punishment in contravention if a company makes any default in complying with any of the requirements laid down in this section. The company shall, without prejudice to any other action under the provisions of this section, be punishable with fine which shall not be less than 10 lakh rupees but which may extend to 1 crore rupees, and the directors and every officer of the company who is who is in default shall be punishable with fine which shall not be less than 25,000 rupees, but but which may extend to 25 lakh rupees, provided that when it is provided that the affairs of the company were conducted fraudulently, every officer in default shall be liable for action under section 447. Section 8 company significant points. Formed for the promotion of commerce, art, science, religion, charity, protection of environment, sports, etc. Requirements of minimum share capital does not apply. Uses its profits for the promotion of the objective for which it is formed. Does not declare dividend to members. Operates under a special license from central government. Need not use the word limited or private limited in its name and adopt a more suitable name such as club, chambers of commerce, etc. License revoked if conditions contravened. On revocation, central government may direct it to convert its status and change its name, bind up, amalgamate with another company having similar object, can call its journal meeting by giving a clear 14 days notice instead of 21 days. Requirement of minimum number of directors, independent directors, etc. does not apply. Need not constitute nomination and remuneration committee and shareholders relationship committee. A partnership firm can be a member of Section 8 company. Formation to promote charitable objects. Application of profits to promote its objects. No payment of dividends out of profit. Type of company limited liability without the addition of words limited or private limited. How status is granted. The central government can grant such status. However, central government has delegated the power to grant license to ROC. Revocation of license. Central government may revoke the license if conditions of Section 8 are contravened or affairs of the company are conducted fraudulently or prejudicially to public interest. Effect of revocation of license. Effect of revocation of license. Company has to use words limited or private limited. Dormant company. Section 455. Where a company is formed and registered under this act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, such a company or an inactive company may make an application to registrar in such manner as may be prescribed or obtaining the status of a dormant company. Inactive company means a company which has not been Inactive company means a company which has not been carrying any business or operations or has not made any significant accounting transaction during the last 2 financial years or has not filed financial statements and annual returns during the last 2 financial years. Significant accounting transaction means any transaction other than payment of fees by a company by the registrar, payments made by it to fulfill the requirement of this act or any other law, allotment of shares to fulfill the requirements of this act, and payments for maintenance of its office and records. Meaning of निधि कंपनीज सेक्शन 406(1) of the Companies Act 2013. In this section, निधि और mutual benefit society means a company which the central government may by notification in the official gazette declare to be निधि or mutual benefit society. As the case may be, निधि companies are created mainly for cultivating the habit of thrift and savings amongst its members. Public financial institutions by virtue FPFI by virtue of section 272 of the Companies Act 2013, the following institutions are to be regarded as public financial institutions: the Life Insurance Corporation of India, established under the Life Insurance Corporate Act 1956, the Infrastructure Development Finance Company Limited, specified company referred to in the Unit Trust of India, Transfer of Undertaking and Repeal Act 2002. Institutions notified by the central government under section 4A2 of the Companies Act 1956, so repealed under section 465 of this act. Companies Act 2013. Such other institution has may be notified by the central government in consultation with the Reserve Bank of India. Conditions for an institution to be notified as PFI: no institution shall be so notified unless it has been established or constituted by or under any central or state act other than this act or the previous company's law, or not less than 51% of the paid up share capital is held or controlled by the central government or by any state government or governments, or partly by the central government and partly one or more state governments. Conditions for an institution to be notified as PFI: established or constituted by or under any central or state act. At least 51% of the paid up share capital is held or controlled by the central government or by any state government or governments, or partly by the central government and partly by one or more state governments.